The Court of Appeals reversed. The easement in this case was created by express grant. Accordingly, the extent of the right acquired is to be determined from the terms of the grant properly construed to give effect to the intention of the parties. By the express terms of the 1952 grant, the predecessor owners of Parcel B acquired a private road easement across Parcel A and the right to use the easement for ingress to and egress from Parcel B. Both plaintiffs and defendants agree that the 1952 grant created an easement appurtenant to Parcel B as the dominant estate. Thus, plaintiffs, as owners of the dominant estate, acquired rights in the use of the easement for ingress to and egress from Parcel B. However, plaintiffs have no such easement rights in connection with their ownership of Parcel C, which was not a part of the original dominant estate under the terms of the 1952 grant. As a general rule, an easement appurtenant to one parcel of land may not be extended by the owner of the dominant estate to other parcels owned by him, whether adjoining or distinct tracts, to which the easement is not appurtenant. Property 412. Plaintiffs, nonetheless, contend that extension of the use of the easement for the benefit of non-dominant property does not constitute a misuse of the easement, where, as here, there is no evidence of an increase in the burden on the servient estate. We do not agree. If an easement is appurtenant to a particular parcel of land, any extension thereof to other parcels is a misuse of the easement. Under the express language of the 1952 grant, plaintiffs only have rights in the use of the easement for the benefit of Parcel B. Although, as plaintiffs contend, their planned use of the easement to gain access to a single-family residence located partially on Parcel B and partially on Parcel C is perhaps no more than technical misuse of the easement, we conclude that it is misuse nonetheless. However, it does not follow from this conclusion alone that defendants are entitled to injunctive relief. Since the awards of $1 in damages were not appealed, only the denial of an injunction to defendants is in issue. Some fundamental principles applicable to a request for an injunction must be considered. 1. The proceeding is equitable and addressed to the sound discretion of the trial court. 2. The trial court is vested with a broad discretionary power to shape and fashion injunctive relief to fit the particular facts, circumstances, and equities of the case before it. Appellate courts give great weight to the trial court's exercise of that discretion. 3. One of the essential criteria for injunctive relief is actual and substantial injury sustained by the person seeking the injunction. The trial court found as facts, upon substantial evidence, that plaintiffs have acted reasonably in the development of their property, that there is and was no damage to the defendants from plaintiffs' use of the easement, that there was no increase in the volume of travel on the easement, that there was no increase in the burden on the servient estate, that defendants sat by for more than a year while plaintiffs expended more than $11,000 on their project, and that defendants' counterclaim was an effort to gain leverage against plaintiffs' claim. In addition, the court found from the evidence that plaintiffs would suffer considerable hardship if the injunction were granted, whereas no appreciable hardship or damages would flow to defendants from its denial. Finally, the court limited plaintiffs' use of the combined parcel solely to the same purpose for which the original parcel was used, i.e., for a single-family residence. Ch11, Easements 413. Based upon the equities of the case, as found by the trial court, we are persuaded that the trial court acted within its discretion. The Court of Appeals is reversed and the trial court is affirmed. Dory, Justice, dissenting. The majority correctly finds that an extension of this easement to non-dominant property is a misuse of the easement. The majority, nonetheless, holds that the owners of the servient estate are not entitled to injunctive relief. I dissent. The comments and illustrations found in the Restatement of Property 478, 1944, address the precise issue before this court. Comment E provides in pertinent part that if one who has an easement of way over Whiteacre appurtenant to Blackacre uses the way with the purpose of going to Greenacre, the use is improper even though he eventually goes to Blackacre rather than to Greenacre. Illustration 6 provides 6. By prescription, A has acquired, as the owner and possessor of Blackacre, an easement of way over an alley leading from Blackacre to the street. He buys Whiteacre, an adjacent lot, to which the way is not appurtenant, and builds a public garage 1/4 of which is located on Blackacre and 3/4 of which is located on Whiteacre. A wishes to use the alley as a means of ingress and egress to and from the garage. He has no privilege to use the alley to go to that part of the garage which is built on Whiteacre, and he may not use the alley until that part of the garage built on Blackacre is so separated from the part built on Whiteacre that uses for the benefit of Blackacre are distinguishable from those which benefit Whiteacre. The majority grants the privilege to extend the agreement to non-dominant property on the basis that the trial court found no appreciable hardship or damage to the servient owners. However, as conceded by the majority, any extension of the use of an easement to benefit a non-dominant estate constitutes a misuse of the easement. Misuse of an easement is a trespass. The Browns' use of the easement to benefit Parcel C, especially if they build their home as planned, would involve a continuing trespass for which damages would be difficult to measure. Injunctive relief is the appropriate remedy. Under these circumstances, Property 414. The Browns are responsible for the hardship of creating a landlocked parcel. They knew or should have known from the public records that the easement was not appurtenant to Parcel C. In encroachment cases this factor is significant. In addition, an injunction would not interfere with the Browns' right to use the easement as expressly granted, i.e., for access to Parcel B. An injunction would merely require the Browns to acquire access to Parcel C if they want to build a home that straddles Parcels B and C. One possibility would be to condemn a private way of necessity over their existing easement in an action under RCW 8.24.010. C. Brown v. McAnally, 97 Washington 2D 360, 644 p.2d 1153, 1982. Notes and questions. 1. What do you make of the reasoning in Brown? What is the point of taking a strict view of the modification of easements if the majority has no intention of following it through to its logical consequence? Would it be better to be more flexible about easement law? Or is the dissent's approach preferable? 2. It turns out that the facts in Brown were a good deal less straightforward than the majority indicates. Elizabeth J. Samuels, Stories Out of School, Teaching the Case of Brown v. Voss, 16 Cardozo L. Rev. 1445, 1451, 1995, What I Discovered. From the record in the case, related land and other court records, and interviews with the parties was predictable in some ways and startling in others. As the reader of the opinion suspects, the conflict between the neighbors had a dark and bitter emotional history. As one cannot easily suspect, the physical aspects of the property differ in legally significant ways from the court's description and understanding. When the Supreme Court of Washington decided the case, the controversy, unbeknownst to the court, was moot, and the party who appears to be the loser in the opinion was in reality the winner. Footnotes omitted. 3. Can you reconcile this case with Jacques v. Steenberg Holmes? 4. Note the range of possible outcomes in easement disputes. It is not so simple as saying the property owner has the right to block the would-be easement holder or not. Cases like Brown honor the property interests of the landowner. Ch11, Easements 415. But by requiring the payment of damages rather than granting an injunction. In other words, the trespasser gets to choose whether or not to continue using the land. Likewise, the right-of-way statutes discussed above allow passage with payment. Recall similar remedies in the adverse possession setting in cases of innocent encroachments. What do you think motivates courts to elect payment remedies in these situations? Why do you think they are not the norm in property law? MPM. Builders, LLC v. Dwyer. 809 N.E.2 D 1053, Massachusetts 2004. Cowan, J. We are asked to decide whether the owner of a servient estate may change the location of an easement without the consent of the easement holder. We conclude that, subject to certain limitations, described below, the servient estate owner may do so. 1. Facts. The essential facts are not in dispute. The defendant, Leslie Dwyer, owns a parcel of land in Raynham abutting property owned by the plaintiff, MPM. Builders. LLC. MPM. Dwyer purchased his parcel in 1941, and, in the deed, he was also conveyed an easement, a right-of-way along the cartway to Pine Street, across M.P.Ms land. The cartway branches so that it provides Dwyer access to his property at 3 separate points. The deed describes the location of the easement and contains no language concerning its relocation. In July 2002, MPM received municipal approval for a plan to subdivide and develop its property into 7 house lots. Because Dwyer's easement cuts across and interferes with construction on 3 of M.P.Ms planned lots, MPM offered to construct 2 new access easements to Dwyer's property. The proposed easements would continue to provide unrestricted access from the public street, Pine Street, to Dwyer's parcel in the same general areas as the existing cartway. The relocation of the easement would allow unimpeded construction by MPM on its 3 house lots. MPM has agreed to clear and construct the new access ways, at its own expense, so that they are as convenient for the defendant as the existing cartway. Dwyer objected to the proposed easement relocation, preferring to maintain his right-of-way in the same place that it has been and has been used by him for the past 62 years. Property 416. 2. Procedural history. MPM sought a declaration, pursuant to GLC 231A, that it has a right unilaterally to relocate Dwyer's easement. When MPM moved for summary judgment, a land court judge found that there were no material issues of fact in dispute. Denied M.P.Ms motion for summary judgment, entered summary judgment against MPM, and dismissed the case. The judge recognized that this case was a clear example of an increasingly common situation where a dominant tenant is able to block development on the servient land. Because of the common law rule, which may well be the result of unreflective repetition of a misapplied rationale. He noted that the rule conflicts with the right of a servient tenant to use his land in any lawful manner that does not interfere with the purpose of the easement. Nevertheless, he concluded that under the settled common law, once the location of an easement has been fixed, it cannot be changed, except by agreement of the estate owners. The judge concluded that, unless this court decides to dispel the uncertainty that now exists and adapt the common law to present-day circumstances, he was bound to apply the law currently in effect. We granted M.P.M.'s application for direct appellate review to decide whether our law should permit the owner of a servient estate to change the location of an easement without the easement holder's consent. 3. Discussion. The parties disagree whether our common law permits the servient estate owner to relocate an easement without the easement holder's consent. Dwyer, citing language in our cases, contends that, once the location of an easement has been defined, it cannot be changed except by agreement of the parties. MPM claims that our common law permits the servient estate owner to relocate an easement as long as such relocation would not materially increase the cost of, or inconvenience to, the easement holders' use of the easement for its intended purpose. MPM urges us to clarify the law by expressly adopting the modern rule proposed by the American Law Institute in the Restatement, 3rd, of Property, Servitudes, 4.8, 2000. This section provides that, unless expressly denied by the terms of an easement, as defined in 1.2, the owner of the servient estate is entitled to make reasonable changes in the location or dimensions of an easement, at the servient owner's expense, to Ch11, Easements 417. Permit normal use or development of the servient estate, but only if the changes do not, a. significantly lessen the utility of the easement, b. increase the burdens on the owner of the easement in its use and enjoyment, or c. frustrate the purpose for which the easement was created. Section 4.8, is a default rule, to apply only in the absence of an express prohibition against relocation in the instrument creating the easement and only to changes made by the servient, not the dominant, estate owner. For it is designed to permit development of the servient estate to the extent it can be accomplished without unduly interfering with the legitimate interests of the easement holder. ID at comment F, at 563. Section 4.8, maximizes the overall property utility by increasing the value of the servient estate without diminishing the value of the dominant estate, minimizes the cost associated with an easement by reducing the risk that the easement will prevent future beneficial development of the servient estate, and encourages the use of easements. Regardless of what heretofore has been the common law, we conclude that 4.8, of the restatement is a sensible development in the law and now adopted as the law of the Commonwealth. We are persuaded that 4.8, strikes an appropriate balance between the interests of the respective estate owners by permitting the servient owner to develop his land without unreasonably interfering with the easement holder's rights. The rule permits the servient owner to relocate the easement subject to the stated limitations as a fair trade-off for the vulnerability of the servient estate to increased use of the easement to accommodate changes in technology and development of the dominant estate. Restatement, 3rd, of Property, Servitudes, Super at comment F, at 563. Therefore, under 4.8, the owner of the servient estate is able to make the fullest use of his or her property allowed by law, subject only to the requirement that he or she not damage other vested rights holders. Roaring Fork Club, LPV. St. Jude's Co., 36p.3d 1229. 1237, Colorado 2001. For we previously have concluded that the dominant estate owner, that is, the easement holder, may not unilaterally relocate an easement. According to the restatement, many jurisdictions have erroneously expanded that sensible restriction into one that prevents the owner of the servient estate from relocating the easement without the consent of the easement holder. Restatement, 3rd, of Property, Servitudes, 4.8.3, Comment F, at 563, 2000. Property 418. It is a long-established rule in the Commonwealth that the owner of real estate may make any and all beneficial uses of his property consistent with the easement. We conclude that 4.8.3 is consistent with these principles in its protection of the interests of the easement holder. A change may not significantly lessen the utility of the easement, increase the burden on the use and enjoyment by the owner of the easement, or frustrate the purpose for which the easement was created. The servient owner must bear the entire expense of the changes in the easement. Dwyer urges us to reject the restatement approach. He argues that adoption of 4.8.3 will devalue easements, create uncertainty in property interests, and lead to an increase in litigation over property rights. Our adoption of 4.8.3 will neither devalue easements nor place property interests in an uncertain status. An easement is by definition a limited, non-possessory interest in realty. An easement is created to serve a particular objective, not to grant the easement holder the power to veto other uses of the servient estate that do not interfere with that purpose. The limitations embodied in 4.8.3 ensure a relocated easement will continue to serve the purpose for which it was created, so long as the easement continues to serve its intended purpose. Reasonably altering the location of the easement does not destroy the value of it. For the same reason, a relocated easement is not any less certain as a property interest. The only uncertainty generated by 4.8.3 is in the easement's location. A rule that permits the easement holder to prevent any reasonable changes in the location of an easement would render an access easement virtually a possessory interest rather than what it is, merely a right-of-way. Finally, parties retain the freedom to contract for greater certainty as to the easement's location by incorporating consent requirements into their agreement. Clearly, the best course is for the owners to agree to alterations that would accommodate both parties' use of their respective properties to the fullest extent possible. Roaring Fork Club, LPV. St. Jude's Co., Super at 1237. In some cases, the parties will be unable to reach a meeting of the minds on the location of an easement. In the absence of agreement between the owners of the dominant and servient estates concerning the relocation of an easement, the servient estate owner should seek a declaration from the court that the proposed changes meet the criteria in 4.8.3. Such an action gives the servient owner an opportunity to demonstrate that relocation. Ch11, Easements 419. Comports with the restatement requirements and the dominant owner an opportunity to demonstrate that the proposed alterations will cause damage. The servient owner may not resort to self-help remedies, and, as MPM did here, should obtain a declaratory judgment before making any alterations. Although Dwyer may be correct that increased litigation could result as a consequence of adopting 4.8.3, we do not reject desirable developments in the law solely because such developments may result in disputes spurring litigation. Section 4.8.3 imposes upon the easement holder the burden and risk of bringing suit against an unreasonable relocation, but this far surpasses in utility and fairness the traditional rule that left the servient landowner remediless against an unreasonable easement holder. Roaring Fork Club, LPV. St. Jude's Co., Super at 1237, quoting note, balancing the equities, is Missouri adopting a progressive rule for relocation of easements, 61 MOL.Rev. 1039, 1060, 1996. We trust that, over time, uncertainties will diminish and litigation will subside as easement holders realize that in some circumstances unilateral changes to an easement, paid for by the servient estate owner, will be enforced by courts. Dominant and servient estate owners will have an incentive to negotiate a result rather than having a court impose one on them. We return to the facts of this case. The land court judge ruled correctly under existing law. But we conclude that 4.8.3 of the restatement best complies with present-day realities. The deed creating Dwyer's easement does not expressly prohibit relocation. Therefore, MPM may relocate the easement at its own expense if the proposed change in location does not significantly lessen the utility of the easement, increase the burdens on Dwyer's use and enjoyment of the easement, or frustrate the purpose for which the easement was created. MPM shall pay for all the costs of relocating the easement. Because we cannot determine from the present record whether the proposed relocation of the easement meets the aforementioned criteria, we vacate the judgment and remand the case to the land court for further proceedings consistent with this opinion. Note: the ability to adapt long-term easements to new uses often depends on formal labels. Suppose a railroad acquires the right to conduct rail service over a stretch of land. Property 420. Decades pass, and the railroad seeks to abandon the line and turn the tracks over to a local government that will tear them out and create a system of nature trails. Can it? If the railroad had acquired a fee simple, sure. But if it only had an easement of way for railroad operations, the change would exceed the easement's scope, giving the owner of the underlying land a claim. Restatement, first, of Property 482, 1944, the extent of an easement created by a conveyance is fixed by the conveyance. This is so even if the easement gave the railroad exclusive access to the land in question while the easement was active. See example Pre-Alt VUS 100 F.3d 1525, Federal Sir 1996. D. Transferring easements. Easements appurtenant. Transferring easements appurtenant is simple. When the dominant estate is conveyed, the rights of the easement come along. This is a natural consequence of the principle that servitudes, such as easements, run with the land. A more complicated problem concerns the division of the dominant estate into smaller parcels. The default approach is to allow each parcel to enjoy the benefit of the easement. Restatement, first, of Property 488, 1944, except as limited by the terms of its transfer, or by the manner or terms of the creation of the easement appurtenant. Those who succeed to the possession of each of the parts into which a dominant tenement may be subdivided thereby succeed to the privileges of use of the servient tenement authorized by the easement. Here, however, foreseeability and the extent of the added burden matters. See generally R.W. Gascoigne, right of owners of parcels into which dominant tenement is or will be divided to use right-of-way, 10a.l.r.3d 960, originally published in 1966, collecting cases. Easements in gross. The modern view is that easements in gross are transferable. Assuming no contrary intent in their creation, example that the benefit was intended to be personal to the recipient. Restatement, third, of Property, Servitudes, 4.6 CMT. 2000. Although historically courts have often stated that benefits in gross are not transferable, American courts have long carved out an exception for profits and easements in gross that serve commercial purposes. Under the rule stated in this section, the exception has now become the rule. Restatement, first, of Property 489, 1944, commercial easements in gross, as distinct from easements for personal satisfaction, are transferable. 491, non-commercial easements in gross determined by the manner or the terms of their creation. Ch11, easements 421. Another issue concerns the divisibility of an easement in gross. Here, too, the danger is that divisibility may lead to excessive burdens on the servient estate. Section 493 of the first restatement of property provides that whether divisibility is permitted depends on the circumstances surrounding the easement's creation. The facts giving rise to a prescriptive easement, for example, may give a landowner fair notice that a single trespasser may acquire an easement, but not that the easement may then be shared by many others once the prescription period passes. In contrast, an exclusive easement might lead to a presumption of divisibility, for the fact that the owner of the servient tenement is excluded from making the use authorized by the easement, plus the fact that apportionability increases the value of the easement to its owner, tends to the inference in the usual case that the easement was intended in its creation to be apportionable. Idcmt. C. Where the grant is non-exclusive, a clearer indication of intended divisibility may be required. Idcmt. D. Section 5.9 of the modern restatement goes further by making divisibility the default assumption unless contrary to the party's intent or where divisibility would place unreasonable burdens on the servient estate. E. Terminating easements. Easements can be terminated in a variety of ways. 1. Unity of ownership. When the dominant and servient estates of an easement appurtenant unite under one owner, the easement ends. Likewise, an easement in gross ends if the owner acquires an interest in the servient tenement that would have provided independent authority to exercise the rights of the easement. 2. Release by the easement holder. The first restatement would require a written instrument under seal for an inter vivos release, while the modern restatement simply requires compliance with the statute of frauds. 3. Abandonment. Abandonment resembles a release. The first restatement treats them separately, however, and distinguishes the two by describing abandonment as intent by the easement holder to give up the easement, while Property 422. A release is an act done on behalf of the owner of the burdened property. Abandonment may be inferred by actions. Restatement, first, of Property 504. 1944. 4. Estoppel. Estoppel may terminate an easement when 1. The owner of the servient tenement acts in a manner that is inconsistent with the easements. Continuation, 2. The acts are in foreseeable reasonable reliance on conduct by the easement holder, and 3. Allowing the easement to continue would work in unreasonable harm to the owner of the servient property. ID 505. 5. Prescription. Just as an easement may be gained by prescription, so too may it be lost by open and notorious adverse acts by the owner of the servient tenement that interrupt the exercise of the easement for the prescription period. 6. Condemnation. The exercise of the eminent domain power to take the servient estate creates the possibility of compensation for the easement owner. 7. A tax deed. Section 509 of the first restatement provides that a tax deed will extinguish an easement in gross, but not an easement appurtenant. 8. Expiration, if the interest was for a particular time. 9. Recording acts. Being property interests, easements are subject to the recording acts, and unrecorded interests may be defeated by transferees without notice. The modern restatement provides for exceptions for certain easements not subject to the statute of frauds and generally for servitudes that would be discovered by reasonable inspection or inquiry. Restatement, 3rd, of property, servitudes, 7.14, 2000. F. Negative easements/conservation easements. In the United States, most of the work that could have been done by negative easements is largely performed by real covenants or equitable servitudes, which we take up in a future reading. See Restatement, 3rd, of Property, Servitudes, 1.2, a negative easement, the obligation not to use land in one's possession in specified ways, has Ch11, Easements 423. Become indistinguishable from a restrictive covenant, and is treated as such in this Restatement. 19th century English law gave negative easements a narrow domain. They were available only to prevent the servient estate from restricting light, air support, or the flow of water of an artificial stream to the dominant estate. ID 1.2 CMT H. Such easements were likewise not widely embraced in the United States, where equitably enforced negative covenants held in gross were disfavored. For the most part, negative easements only arise by agreement or grant. U.S. courts therefore consistently reject the English doctrine of ancient lights, which recognizes a right to light from a neighbor's land after the passage of time under certain circumstances. 4-34 Powell on Real Property 34.11. The limitations of negative easements complicated efforts to create conservation and preservation easements. Such easements tend to be held in gross, example by a conservation organization, and the common law prohibited equitable enforcement of negative covenants held in gross. The law likewise was skeptical about expanding the categories for which negative easements were available. Restatement, 3rd, of Property, Servitudes, 1.6 CMT. A. 2000. The problem was addressed by the Uniform Conservation Easement Act, which has now been adopted by every state. 434A. Powell on Real Property 34A.01.